Good morning, everybody, and welcome to the District of Columbia Court of Appeals. We have one case on this morning's calendar, and it is number 24 CO 168 Malik Hewitt versus United States. Mr. Madsen, whenever you are ready.
Good morning, Your Honors. May it please the court, Adrian Madsen on behalf of Appellant Malik Hewitt. I'd like to reserve 3 minutes for rebuttal. Where this court does not specify otherwise, a trial court on remand for resentencing due to merger has discretion to determine which conviction to vacate and which to leave in place, felony murder or a predicate felony. Discretion trial courts will no doubt exercise judiciously. This court has so held in, among other cases, Bonhart and Price, a point underscored by this court's more recent decision in Young, applying the principle and, after full briefing, stating, quote, "We agree with appellants that the trial court retains discretion over how to effectuate the merger and resentence appellants on remand." Because Bonhart and Price predate Mooney, and Mooney is contrary to Bonhart and Price control.
Explain something that seems relevant to a lot of the issues that come up here, which why is second-degree murder a lesser offense of felony murder?
Your Honor, that is a good question. I will say that in these cases, both Bonhart and Price, and frankly, for that matter, I believe in Young as well, this court characterized the second-degree murder at issue in those cases as a lesser included offense. I agree with Your Honor that analytically, their second-degree murder is not always a lesser included offense, but that is how this court treated it in the relevant opinions.
Do you think that the court did treat felony murder, second-degree murder? Sorry, I've not had enough coffee. Do you think that the court in Bonhart and Price, well, really Price, because Price comes first, right? Treated second-degree murder as a lesser included of felony murder, and here's why I ask, right? If second-degree murder is a lesser included of felony murder, and if the rule is we always merge lessers into greaters, you would think what would have happened in Price is that the court would have said, well, the predicate felony merges into felony murder, and the murder merges into felony murder, and we're done, right? But that's not what the court said. Somehow it found a choice not to do that. And that seems inconsistent with saying that second-degree murder is a lesser included of felony murder.
I guess two things, Sharon. One, I'd be happy to pull the quote, but yet I'm nearly positive in both Bonhart and Price, this court referred to the second-degree murder as being a lesser included of the felony.
Maybe so, but my point is that the analysis seems in tension with that statement.
Your Honor, I guess from Mr. Hewitt's perspective, that is sort of the reason we are here today. That is that the court does have discretion. It's apparent that this court has treated homicide differently than other offenses. We know that, for example, sort of regardless of whether the second-degree murder was a lesser included of the felony murder being first-degree murder is undoubtedly greater than the second-degree murder. And where this court has repeatedly, where there is a second-degree murder conviction and a felony murder conviction, even if that wasn't the analysis, the court is at the end of the day in these cases saying, trial court, you have discretion to either leave in place the second-degree murder and the predicate felony, or you can leave in place the felony murder. So even regardless of whether the court was treating it as a lesser included, it's certainly a lesser offense. And this court has repeatedly, again, Bonhart, Price, Young more recently, indicated that the trial court has discretion between those two options.
What about Garris? Garris says if you have offenses, and in Garris, it's first-degree murder and felony murder that have mandatory minimums, that you have to sentence the defendants to those mandatory minimums. You can run those mandatory minimums concurrent to each other, but you can't, you can't vacate either offense. I'm not sure that that part of Garris still survives. I didn't sort of run that out. There's so many threads in this case, it gets a little confusing, but just for the point of if double jeopardy is about ensuring that you're not punishing someone for more than the legislature wants them to be punished, but the legislature has already said you have to punish someone for this crime with this mandatory minimum. Garris seems to say you cannot ignore that mandatory minimum. You have to sentence them to that. And so, you know, in Garris, I think, now I'm getting confused what happened in Garris, but, in Garris, actually, the defendant, I think, wanted the felony murder to be preserved and wanted the first degree murder conviction to be vacated. And the court just said, no, you have to have both. But that just seems, again, in tension with, if not inconsistent with, this court's determination in Bonhart and Price that, okay, you've got felony murder with a mandatory minimum, but you've also got a second degree murder and a predicate felony, and you can just choose. And of course, if you choose to vacate the felony murder and just go with the second degree murder and the predicate felony, you don't have a mandatory minimum confining you. So that just seems, I don't know how to reconcile those cases.
Your Honor, I agree with the court. I think that's what the trial court Judge Kravitz was saying here, that he wasn't referring to Garris specifically, but this court's case law is not obviously consistent on this issue. But what is consistent from Price, which predates Garris, is that
No, Garris predates Price.
Right,
Garris-
and then there's the fact that Franklin and Franey and Fuller all predate Bonhart and Price. So what of that?
Just to stick with Garris, and then I'd love to hear your response to Judge Thompson. Garris is 1985 and Price is 1987. And if your argument is, well, Bonhart and Price predate Mooney, it seems like, well, Garris predates Bonhart and Price.
I agree that Garris predates Price. I will say, in terms of the argument the government advanced here, turning to the end of its brief, the government's point was that even if Bonhart controlled, and even if Bonhart was inconsistent with, or Mooney was inconsistent with Bonhart, the government was relying on Franklin and Franey, not on Garris.
So let's go to Judge Thompson's question then, and I apologize for diverting you from that.
No, and certainly, Your Honor. I mean, so I guess starting with Franklin, Franklin is a rule of priority case. The statement that the government relies on from Franklin is, one, is dicta, and two, as is apparent from the discussion that we were just having with Judge Easterly, that this court has unquestionably treated homicide offenses differently from non-homicide offenses in this merger context. And Franklin was
Can you
not.
just explain the rule of priority?
Sure. So normally when a trial court now is instructing and there are greater and potentially lesser offenses, the trial court says under this rule of priority, if you if you convict of the greater offense, stop there. Don't go on and deliberate about these lesser offenses.
Can I just interrupt there? That's what I thought the rule of priority was, but then reading Franklin, I'm confused because these are my notes from Franklin, that the government was arguing that there was a rule of priority between convictions supported by sufficient evidence and those not. And Franklin, I think, if my notes are accurate, is a case where the defendant was charged with burglary and larceny on the one hand, and then receiving stolen property on the other. And the court was saying, well, both can't be true. I mean, when you steal, when you rob someone, when you burglarize someone, I guess you are, as the perpetrator, receiving the property to yourself, but that's not what the receiving stolen property crime is. That's by a third party. So these are two. So so the court was saying receiving is not a lesser included of burglary and larceny. And so I didn't understand the court to be talking about this rule of priority in sort of the sense of, well, instruct the jury that they can only consider this and then they can go to the lesser included. That's not what Franklin is about. Franklin was about, well, look, we just think that there is zero evidence that he received stolen property because he was the theory that won out was that he was the one who actually stole it. So that's why we're vacating the receiving stolen property offense. But then we're going to give the court discretion about how to sentence him on the burglary when we send it back.
So I guess a couple of things, Your Honor. One is I understand the rule of priority the same way Your Honor does. As far as Franklin goes, what I understood, I guess I will say the way that this court, and I understand there's an issue of precedent on precedent, but has subsequently cited Franklin is for this rule of priority, not in the manner, and I'm not taking it
Sort of divorced from its facts.
Right. And I made a note about Franklin too. My note says, shouldn't even have considered lesser offense unless acquitted of greater offense. I think it does stand for that, which caused me in looking at Price and Bonhart to think about how is it that in Price and Bonhart, there was this second-degree murder conviction to start with. How'd the jury get to second-degree murder? So it seems to me in addition to the fact that Franklin and Fuller and Franey all predate Price and Bonhart. An additional reason, it seems to me, not to kind of ride Price and Barnhart as far as you can take them, is that they offered this alternative, vacate this or vacate that, even though that never should even have gone to the jury. They're just fraught with problems, it seems to me.
I think the way it came up in to answer Your Honor's question in both Bonhart and Price, and more recently, for example, in Young, is that the government had indicted indicted on both first-degree premeditated murder, or in some cases potentially second-degree murder, and so we had both. I will say the trial court in this case did something different, and I'll talk about that in a second, but the government had these alternate theories of murder, and so because the jury was not instructed, if you get to felony murder, stop, right? We have this other theory of first-degree premeditated murder that has different elements, but notwithstanding the fact that it has different elements, the way that this court has treated that, both again in Bonhart, Price, and more recently in Young, is that the felony murder that the second-degree murder is a lesser included of the felony murder. I agree that analytically there could be at the trial court level there could be issues like with that. I mean, take for example Mr. Hewitt's facts. That is, the trial court didn't give a second-degree murder instruction because it concluded that it would have required a bizarre reconstruction of the evidence. Notwithstanding that, binding precedent, right, from this court in Bonhart and Price says we're going to treat the second-degree murder as a lesser included of the felony murder. And so it seems, but to go back to Your Honor's sort of initial question, it seems clear that this court is applying a different rule in the homicide context than it is outside. Both Franklin, Franey, Fuller, none involved homicide, and this court is apparently applying a different rule in the homicide context.
I'm sorry, can you just go back to the point? I wasn't following along, so I'd just love for you to repeat it. That you said that in this case, there was no felony murder, or there was no second-degree murder instruction. And you mean as to Mr. Hewitt?
To Mr. Hewitt, yes.
Okay, but I mean, wasn't that because there was just no evidence to support a second-degree murder? I mean, he's sitting in the car. Okay,
Right.
So then what was your follow-on point?
Sure. So the follow-on point is that both Your Honor asked, and I believe Judge Thompson asked at one point, sort of, and maybe Judge Beckwith as well. I'm sorry. So maybe this is coming from all of the panel here.
Yes.
How is
Minds want to know.
how is second-degree murder a lesser included of felony murder? And My answer is to say that I agree that analytically it is not always, right? I mean,
As in this case, for example, because I was going to ask you, what's your example of when it is not? And
Right,
this
as in
case would be your,
right, the
yeah.
trial court concluded it would have required a bizarre, reconstruction of the facts, so, didn't give the second degree murder instruction. And so it wasn't, in this case, but notwithstanding that, in both Bonhart and Price, this court has said that felony murder, excuse me, I keep doing, second degree murder is a lesser included of the felony murder.
What are the sentencing ramifications? There, for second degree murder, no mandatory minimum, but what is the sentence for second degree murder?
That were the maximum penalty. I believe, standing here, I'm sorry, that wasn't the focus, but I
Okay,
believe it is
yeah.
40 years.
Okay, I'm just curious.
There are,
Happened with Mr. Hewitt's co-defendant, not the woman, but the Mr., is it Everett? Is that his name?
that's correct, yes.
What was his sentence? What was he convicted of?
So he was convicted of felony murder, some additional accounts of obstruction that Mr. Hewitt was acquitted of, PFCV, possession of a firearm during crime of
Second
violence.
degree murder?
No, because in this case, the trial court instructed, applying the rule of priority, said, don't go on to second degree murder if you convict of the greater offense. So his sentence was, at least prior to the remand, was, I believe, about 37 years. I think that I didn't track that close, but I think that stayed the same after the remand in his case as well, which was sentenced separately for logistical reasons.
It's not in fact the case that Mr. Hewitt got a greater sentence than the shooter in this case.
No, he did not. That is, I mean, Judge Kravitz has this discussion at the time of the original sentencing about the fact that there is this mandatory minimum sort of leaves him without giving, a wildly disproportionate, or what he referred to as a wildly extreme sentence to Mr. Everett, that there was no way really of reflecting in the sentence the different culpability between them. No, he did not receive a greater sentence. No, it was not significantly different, given the mandatory minimum of 30 years, but no, he did not receive a greater.
Your point is under Bonhart and Price, that's theoretically possible.
That's right. And this court has said as much in those cases. I see that my time has expired. I'll reserve the remainder of non-existent time.
Okay, we will give you the 3 minutes you asked for. So,
Thank you.
Mr. Sable.
Good morning. May it please the court, David Sable on behalf of the United States. First, this court has decided, our view is this court decided on direct appeal which conviction needed to be vacated. When the court said, we agree with the parties who all asked to vacate the lesser included offense, specifically Mr. Hewitt did, we did. And then the court said, we remand for merger purposes, but said we agree, and cited Matthews where the court ordered vacatur of the lesser included predicate felony to the felony murder.
It didn't actually specify which count would be vacated, right? You're talking about our first, our MOJ affirming in the direct
I'm
appeal,
trying to persuade you
yeah.
that you did specify
Okay.
in so many words.
just because of the existing law at the time would have implicitly meant that's what we meant.
Well, not just the implicit law. Yes, that would be one reason to say that. But the other reason would be to say, we agree with what the parties are asking us, and the parties all asked the court to vacate the lesser included. And then the court cited Matthews where the court ordered the trial court to vacate the lesser included. So putting those three together, yeah, I think the court reached this issue. And therefore it's law of the case at this point.
I feel like it's, the merger questions are often, okay, we agree there are some double jeopardy issues here. We're sending it back and let the trial court deal with it. I guess, if your argument is that everyone was on the same page about it, maybe that's different from your average case, but it does seem like we often send it back without that much specificity.
Right. That might be the case. I mean, I'm not on this side.
Yeah,
You're on that side. I'm not.
I-
But
Yeah.
I would say this happened when it went back down, and then Judge Kravitz at the first hearing said, hey, I have this crazy idea because I see some tension between these two lines of cases. How about you brief this issue? And then the parties briefed it, and that's why we came back. But our view is everybody thought that the predicate felony would be vacated, and that's law of the case. But if I don't convince you of that, I want to go ahead and say that it's very clear that where you have one murder and one homicide conviction, that this, on remand for merger purposes, the court has to keep the murder, has to keep the more. Remember, this court has never said that.
Sorry, I thought I heard you say where you have one murder and one homicide conviction. Is
Yeah.
that what you meant to say that?
Right, we have.
Okay, sorry, I'll let you continue.
Right, so we have one murder and one homicide conviction.
One person killed and then one conviction.
One,
based on
yes,
that, yes.
one count.
Okay, sorry,
One
not one
count.
murder count, one
Right.
homicide conviction.
Then the court has never said, oh, hey, you can just get rid of the homicide. That would usurp the function of the jury, which found a homicide conviction. That would plainly violate the clear intent of the legislature, as Judge Ruiz said in Mooney and the Supreme Court said in Jones, and it would fly in the face of common sense. And also, and I would say, so we have several different scenarios. So we have a case where the government charges felony murder, first degree murder on a felony murder theory with a predicate felony. Sometimes we have several felony murders, and then we have first degree premeditated murder. And sometimes the defendant is convicted of felony murder and murder one, premeditated murder, and sometimes convicted of, that's Jones. I'm sorry, that's Price. And then sometimes we have murder two. I'm sorry, we have murder two as a lesser included of first degree felony murder, or sometimes just a plain old murder two. And in those scenarios, the court has said the trial court has discretion. And how it got there was that in Garris in 1985, there were two first degree felony murder convictions. And the court said, well, you have two first degree felony murders, the trial court can pick one. Actually, what the trial court wanted to do was vacate the felony murder and then run the predicate felony consecutive to the first degree premeditated murder. The defendant said, hey, that's not fair. And this court said, well, sentencing package doctrine, Thorne, the trial court can effectuate the original purpose of its sentence, and you get to choose which first degree murder you vacate and which you keep, and you can put your sentence together. And then 2 years later, we had Price, where we had a felony murder and then a murder two as a lesser included of a premeditated murder. And the court said the same thing, citing Garris and Price. But the difference between those two is that where you have two felony murders, two first degree murders, they violate the multiple punishments clause of the double jeopardy, but neither one is a lesser included. But then when you go to murder two as a lesser included of first degree premeditated murder and felony murder, this second degree murder is technically a lesser included of the felony murder, because this court has said that the predicate felony gives you the mens rea for the first degree murder. That's why murder two is a lesser included.
Do you think that's right?
I mean, it's not in this case, because as Mr. Madsen has pointed out, HEWITT, there's no construction of the facts that support HEWITT being a principal, in this case. So there was no possibility for him to get murder two, and in this case, so no. But theoretically, I think that's the law.
It is, we did say in Mooney quoting, is it Jones? Like,
Yes.
we can't imagine that the legislature wouldn't want you to be punished for the murder, but
Would not want you to be
would
punished.
not, sorry, yes. But Jones, of course, the shooter, the defendant was the shooter, right? Mooney, he wasn't. And so it felt like we sort of took a step. I mean, our felony murder statute allows for that, because our felony murder statute allows punishment of people who weren't actually the shooter, but it is sort of a conceptual step, perhaps, to say, well, we can't imagine. I mean, as you say, like, there's no theory under which Mr. HEWITT actually engaged in the crime of murder. He just aided and abetted a robbery, and then
An armed robbery.
Armed robbery,
Yes,
yes,
well,
not
he-
to minimize it.
I mean, I would
but-
say, first of all, this court said he was integral to the conspiracy. It was his idea to target Heard. It was his idea. He's the one that called or used his phone to call. And so this court found that he was very much involved in the plan. And obviously I'll just say briefly, when you're robbing a drug dealer, particularly somebody selling PCP out on the street, you have to expect that they've got some way of defending themselves, because you're going to get robbed if you're selling drugs without access to weapons. So, I mean, I don't think that, but so that is the predicate, that is the felony murder theory. And in Jones was a felony murder with a predicate felony, where for some reason they were sentenced consecutively. And by the time they got around to vacating the predicate felony, he had served his predicate felony because it was stacked in that order. And then he made an ex parte Lang claim. And the court limited ex parte Lang, as it usually does, and then said, come on, you cannot think, in double jeopardy, we always go for legislative intent first before we go to blockbuster. You cannot reasonably think that the Congress intended the guy not to serve the murder. And that's what Judge Ruiz quoted. So Jones is really very much on point. And in fact, what the court said in Jones, got it here somewhere. The court addressed the situation with the multiple murders. Well, I don't have the full quote in front of me, but the court did say that. If you look at the full quote from Jones. Oh, here it is. But here, the full quote in Jones is, but here the legislature plainly intended one of two results for persons who committed murder in the commission of a felony. Either they were to be convicted of felony murder, or they were to be convicted separately of the felony and of non-felony murder. It cannot be suggested seriously that the legislature intended an attempted robbery conviction to suffice as an alternative sanction for murder. I think that's on point.
So just getting back to first principles here. I mean, I know the government stands by Mooney and all the cases that preceded it, but what do we think is the operative principle? It's legislative intent. It's about sort of what I mean, double jeopardy is about making sure that the punishment isn't more than what the legislature wanted, right? But there also seems to be floating around in the case law sort of ideas about usurping the function of the jury or giving the trial court deference. Is it about ensuring the greatest amount of punishment? Is it?
I think you've just, that's my answer. Yes, it is. So,
Yes to all.
so, I mean,
All of the above.
Fuller in 1967 was a homicide case, and they talked about usurping the function of the jury. So if the jury finds a murder conviction, one of the things that the judge gets discretion to do is not getting rid of a homicide conviction that's perfectly valid, that's found by the jury, which is what we have here. You just can't do it. That's not in your bag of tricks, trial court. It's just not. And then that's one idea. The other idea is that nobody thinks the legislature would have thought.
I mean, just sorry to interrupt, but except that that's exactly what happened in Bonhart and Price, right? Like,
No,
No?
because you had two homicide convictions for one body, and the Court of Appeals said, hey, trial court, as long as you keep one of the homicide convictions, we're happy with you putting together the sentencing package.
but
There has to be
you
two
still
murders.
have a jury. I mean, I guess what I'm still tripping over, and you can tell me why this is wrong, is that the jury is saying, we think this is felony murder that has a mandatory minimum sentence. And the jury is also saying, we think this is second degree murder that doesn't have a mandatory minimum sentence. And you'd think that if we don't want to usurp the function of the jury, then we'd always say, you got to go with the felony murder with the mandatory minimum. I mean, that seems to the desire not to usurp the function of the jury, the desire to maximize punishment, the desire to, adhere to the legislature's desire for mandatory minimums, all would seem to point one in the direction of saying that Bonhart and Price are wrong, because they should have just said, there's no discretion here. There's just a mandatory minimum, felony murder that has to be imposed. And yet in Bonhart and Price, it seemed like the court was really saying, well, wow, there's this wellspring of trial court deference and sentencing. And so we're going to let that kind of outweigh all these other factors.
Two things, Your Honor. First of all, we're not in a Bonhart Price scenario.
I hear
know-
you.
I know-
I'm
I know
just
you know
trying to get
that.
to principles.
So,
of
and
the- like,
I
what's-
think just, we have to read Judge Ruiz's opinion in Mooney in light of the facts, where you had one homicide and one homicide conviction. I don't,
Truly, I get that, and truly,
And,
but I just want
mean,
to
you write opinion,
understand,
so you
like,
know.
do you, is the government's position that Bonhart and Price are just wrong? Or does the government have an understanding of Bonhart and Price that's different than what I just was describing of?
That was gonna be my
Of
second point.
okay, go for it.
What did you
Sorry.
just say? I didn't hear what you said.
I said that was gonna be my second point.
Okay, thank you.
I don't think I see Bonhart and Price the way you do. I mean, yes, it could have come out the way that, hey, we don't think, you don't get sentencing package when you've got a murder two and that's 0 to 40. I mean, that's just not, that's too much discretion. The court could have said that. But I don't think Garris could have, I don't think Garris turned so much on maximizing punishment. I mean, it was about giving the trial court discretion to put together the sentence that it thought was appropriate. And I don't think it necessarily turned on mandatory minimums, although it did discuss that. The idea is you've got two first-degree murder convictions where and this court has said over and over, there are more cases after this where there's one murder, there can only be one murder conviction, right? And so
I'm sorry to interrupt, but you said this earlier, and so I just want to make sure, and maybe I just need to go back and reread Garris. But I thought Garris did make a big deal of the fact that it was a mandatory minimum for first degree murder, and said you cannot, and I thought the court suggested in Garris, which puzzled me, that you actually had to keep the first degree murder and felony murder convictions in place because each of them had mandatory minimum sentences. But maybe I'm just totally.
I read it that way too. I'm not sure I
misreading.
read because they were mandatory minimums, but I read it as both stand, the first degree murder and the felony murder.
Right, I'm looking at page
Garris,
513 and spanning sort of the bottom of 513 into 514. Right, where appellant is arguing that on remand, the court improperly vacated the felony murder in order to sentence him consecutively for the robbery with the first degree murder. The court is agreeing, look, something had to be vacated, but because the first degree murder statute establishes a mandatory sentence of 20 years to life, the trial court was required to sentence Garris for both the premeditated and felony murder counts. I don't even know what to make of that. Required to sentence him for both the premeditated and felony murder counts. And then the court goes on to say, look, you can make it consecutive, but it does seem to say that you have to have both of them.
really? I didn't,
Maybe
it's hard for me
I,
to reread the whole case right here. but
yes, no, I totally
I didn't read it
understand.
that way. I thought the
Okay.
court said, you gotta, there's a case that follows on to this called Thacker, which is another first degree murder case, which is,
Maybe Thacker makes more sense. And
I
I can look for that because I thought it was sort of
Thacker?
surprising as a double jeopardy matter that the court in Garris would say you have to keep both offenses.
no, you can't do that. I think
Right.
Doak said you can't do that even if you run them. It violates the multiple punishment clause to convict somebody for felony murder and first degree murder while armed for one body.
Right,
even if
so
you run them
if that-
concurrently.
Yeah, so if that's,
Even though
if
it's not a
that's
lesser included, it's a violation of the multiple punishments provision.
right, and I get that, and this is just one of the like 1,000 things that's confusing about this area of the law, but if Garris was putting weight on the fact that the legislature had said that this sentence is a mandatory minimum, then, you know, your point of like, no, but you can only have one murder conviction for one death, seems in tension with Garris's reliance on that. And then, so if we think Garris didn't or couldn't have really meant what it said, then maybe Garris isn't so much in tension with Bonhart and Price. I just, you know, I sort of start sliding down the slippery slope again.
I don't.
See what I'm, do you see what I'm saying? Am I?
Yes, but I don't think
Yes.
that, I mean, I just think that that's not what Garris says. I think Garris said they, I mean, I guess I'm gonna be embarrassed if you both, you know. That Garris said they had to vacate one of them, right? You can't do that. So it's very clear in this jurisdiction that when you remand in a Garris scenario, the court can only keep one of the first degree murders. And so, but again, I'm trying to convince you that every time the court talks about these remand scenarios, it talks about the felony murder, multiple homicide for one body scenario as a completely different exception. And Judge Ruiz did it in Mooney too. She cited Parker and she cited Bonhart, and she's talked about it as this exception over here. So when she says, yeah, you always got to vacate the lesser included on remand, she's recognizing, and she wrestled with the idea that, you know, this is out there. She just, you know, there's a superficial tension if you take the sentence of her holding and compare it to Bonhart and Price. And Mr. Madsen or Judge Kravitz caught that. And that's why we're here, but it's a superficial tension.
Yeah, I was saying earlier that as I tried to figure out how Bonhart and Price went wrong, because they seemed to be wrong to me, I thought it was because they were stuck, the court was stuck with the situation where there was this second-degree murder conviction that shouldn't have been there because the jury, under this rule of priority, should never have gotten to second-degree murder. I mean, that's what's wrong with those decisions, I think. Do you disagree with that?
In some cases, if we charge felony murder and say, Judge, could you instruct the jury on the lesser included of murder two, and you come back with both, that's clearly wrong. But if I charge first degree felony murder, premeditated murder, and a felony murder, and the jury comes back with both, that's not wrong. We have to vacate one, but it's okay for the jury to do that. That doesn't violate the rule of priority consideration.
Right, but what Price and Bonhart said is, as I recall, maybe I'm wrong about this, is that the court said in those cases that you could vacate the felony murder and leave the arson to stand, or you could
In Bonhart,
vacate arson and leave felony murder to stand. And that's what seems to open the door that Mr. Madsen is urging us to walk through.
right, so Bonhart was an arson case, and so he set the arson. I guess the victim walked back into the building to save his dog, and then so the government had two theories. One was a felony murder theory, and the other was a murder two theory. They were different charges on different theories. These multiple homicides
This
are
part was a case where it was totally fine for those two charges to go to the jury because of the different factual theories that the
Yes.
government had.
So when the
Okay.
government has multiple charges homicide on multiple theories, maybe that's a better way of thinking about it. We charge homicide on multiple theories. We frequently come back with multiple homicide convictions, but they always have to be remanded out, vacated out if there's only one body. So Bonhart was convicted of second degree murder as a principal, and then he was convicted of felony murder with the arson. And the court said, you know, trial court, you get to pick. You got to keep one of the murders. And if you keep the
Puzzling over how you know that he wasn't convicted of second degree is sort of how you know that the jury was properly allowed to return both verdicts in that case. How do you know that? Is there something
I
in
think
the
it says
case
that
that
in the
tells us
opinion.
that?
Yeah, that says that he was convicted on two theories.
Because it turns
We have
out how the government presented the case, right? I mean, presumably the government in closing laid
the
it out.
instructions.
And in the instructions, laid it out for the jury. Look, we think he's guilty on this theory. We think he's also guilty on this theory.
If the rule of
Right.
priority is violated in a case, isn't that equivalent to allowing the jury to convict under two theories? I'm not sure why the invoking of two theories solves the problem, if you follow me.
Sometimes the rule of priority consideration comes up when the court makes an error in allowing the jury to reach convictions that it shouldn't have reached, doesn't instruct properly, which is what happened in Fuller. I think in Fuller was a homicide. It comes up in the scenario that Judge Easterly just talked about, where you have like this Gaddis case was a Supreme Court case where they was convicted of robbing the bank and then possessing the proceeds. But they're on different theories. Like he could have robbed the bank and been a principal, but he could have just received the proceeds later. But if he robbed the bank and kept the proceeds, we can't let him keep, we can't keep the proceeds charged, right? So that has to be vacated.
Well, this may be a rabbit hole anyway. I was going through this mental exercise as I struggled to figure out how Bonhart and Price could have gone so wrong and how they could be reconciled with the others. And I
mean,
guess I didn't get there.
I do think that Judge Easterly could be right that if this panel were to decide Price as a matter of first instance right now, you would not decide it that way. That you would think, hey, I know you have a murder two over here that's 0 to 40, but you have a felony murder over here that's 30 to, well, in that time, 20 to life or 30 years. We don't think that the murder two does service for the felony murder conviction. We think that's also usurping the jury, but that's the way it came out. But even if you think that those opinions are wrong, it's clear that they are an exception that this court created that only applies when you have two murder convictions for one body, and it doesn't apply where you just have a garden variety, simple case with a felony murder and a predicate felony. It would simply just, for all the reasons that I've articulated, not be appropriate to just vacate the felony murder and have Mr. Hewitt only be convicted of attempted armed robbery. Thank you. We'd ask that the court affirm the conviction. Thank you.
Mr. Sabol. Mr. Madsen, we will give you 3 minutes.
So I'd like to go back to Judge Easterly's question about, is this the greatest punishment, right? What is the underlying principle here? And I think that it's important to, the government has no statutory or constitutional countervailing right? What brings us here is double jeopardy. And there are multiple ways that, leaving aside the other case law, multiple things that could cure a double jeopardy problem. This court in Bonhart, Price, more recently, and Young has said the trial court has discretion in terms of the way it goes about this, but the government has no statutory or constitutional right to a particular conviction, whereas Mr. Hewitt or anybody in her circumstance has the constitutional protection against double jeopardy.
So I understand the general point that we're here because of double jeopardy concerns, right? So something's got to go, right? So, but then you said the government doesn't have any sort of right to the felony murder conviction, and that's why I'm focused on these mandatory minimums, because it seemed like Garris said actually that does give. It's not the government's right. It's sort of the legislature's mandate that you have to hand out these mandatory minimums when they're available to you. So that's what I'm struggling with, is that does seem to be the countervailing. Like if you have a case, I think it's like Thorne maybe, where you've got two robberies, right, on two different theories, then, you vacate one of them and, if felony murder didn't have a mandatory minimum, then maybe I just don't think we would be here, right? We would be squarely in the land of giving the trial court discretion as to how to sentence. But it's the mandatory minimum that I'm really bumping up against.
I understand. I just the difficulty with the government's argument here is that saying that allowing Judge Kravitz to do what he indicated he very likely would do if he had discretion to do that usurps the function of the jury is the point that Your Honor was making with Mr. Sable, is that where second-degree murder is a lesser included of felony murder, and this court is repeatedly telling the trial court in all these cases, Bonhart, Price, more recently Young, you have the discretion. So leaving aside the one body can't give rise ultimately after merger to more than one homicide conviction. Still, what this court is saying is, trial court, you have discretion, notwithstanding the fact that there's this felony murder with a mandatory minimum, that you have discretion to leave in place the lesser offense. So if the government sort of cites to this nebulous idea of not usurping the function of the jury, but that's exactly what this court has done, right? And so and the principle would so there's no sort of like limiting principle. The government is saying it would essentially create this windfall, but this court's decisions already do that in Bonhart, Price, and Young. If the trial court was required to leave only to sentence on the greater offense, then all of these cases are in tension with that. And I would just in Price, to go back to sort of where we started here, this is at note 7, because second degree murder is a lesser included offense of felony murder, one of those convictions must be vacated upon remand, right? So this court is expressly saying, this is a lesser included and treating it that way. And so there's no, the government's theory doesn't, or argument here doesn't hold, because if the trial court was simply required to impose the sentence on the greater offense, then all of these cases are wrong.
Mr. Sable says, though, that Price and Bonhart stand for this special rule that applies where there are 2 murder convictions for one body. That's the situation that they address.
It is
Then
true
they
that those
allow-
are the facts of those cases, but that is in tension with even if that was the case, even if it was this special rule, which none of those cases identified in that manner. Still, what's left is that at the end of the day, the court is saying, trial court, you can choose between the lesser and the greater offense, felony murder and second degree murder, and so the government's argument just doesn't work. I would also just, and I don't want to spend much time on it, but in terms of what the government actually, because the court has, I think, appropriately reached the merits here, in terms of what the government asked for on direct appeal, the only sentence the government included was at page 40 of its brief, footnote 16. For the same reasons, we agree with Hewitt that his conviction for attempted armed robbery merges with his conviction for felony murder while armed. Right? There's no request from the government here. Same in the MOJ, and I'll just note, in terms of the weight the government is asking the MOJ to carry here in the penultimate paragraph on page 11 of the MOJ, it actually refers to convictions that Mr. Hewitt doesn't have. So it's just very clear that there wasn't a lot of thought given to, respectfully, a lot of thought given to that issue, given the agreement.
But Mr. Hewitt did ask for the lesser to be vacated, right?
I agree, he did, and as indicated in the reply brief, I think the government waived that by not raising it below.
What did the MOJ refer to? Convictions that Mr. Hewitt didn't have?
Yes, that is, so the last full sentence before the parenthetical, and accordingly, appellants, referring to appellants in the plural, 2 associated convictions for possession of a firearm during a crime of violence also merged. Mr. Hewitt was acquitted of the PFCV. So just in terms of the level of attention that might have been there about that.
Counsel, I mean, say for the sake of argument that we thought your principled analysis of Bonhart and Price was correct and was not consistent with Mooney. The fact of the matter is we've applied Mooney a number of times. We've relied on Mooney. So, I mean, do you really think that this panel could on its own just declare Mooney bad law? Wouldn't we have to go on bonk to say, something's not right here? There's some contradiction in our law.
I guess, no, Your Honor, I don't think the court would need to do that with Bonhart and Price being earlier. I mean, the court has also cited it Bonhart and Price. I mean, as recently as 2023 in Young, when the court was this court, another panel of this court was another division of this court was saying, trial court, you have the discretion between those two things after the issue was briefed, that this is what this court decided. But I think the court certainly could go en banc to address it. And I agree that there are certainly inconsistencies in the case law, but with Bonhart and Price being earlier than Mooney, I don't think the court would be required to do that. If there are no further questions, we would ask that the judgment of the Superior Court be reversed and for Judge Kravitz to be permitted to exercise discretion as he indicated he very likely would. Thank you.
Mr. Madsen, thank you, Mr. Sable. Thank you for your briefing and your arguments in this case. Good to see you, Ms. Kolb. We will take this one under advisement.
All rise.